Hello everybody, welcome to this class on International Human Rights and Humanitarian Law, unit code BLW4208. My name is Nancy Kabaki from the Mount Kenya University School of Law. Today we are going to continue looking at what is humanitarian law. And last time we had a look at what are the fundamental principles of humanitarian law, of international humanitarian law. And we saw that humanitarian law is that branch of law which seeks to limit the effects of armed conflict by protecting persons who are not participating in hostilities. So it is important to know who are the people who are participating in hostilities and how can they be protected. How does international humanitarian law do this? We saw by regulating the means and method of warfare. Interesting to note, but you can, and the means and method of warfare are actually regulated. One fundamental thing that we also see in international humanitarian law is limiting the rights of parties to conflict to use method and warfare of their choice. And finally, what international humanitarian law seeks to do is to balance humanitarian concerns as well as any military necessity. Interesting that the law does not stop a country from engaging in war. The United Nations does not give a condition that you cannot use force. But what they do is to limit the force that you can use and to do what they call a legal war or an illegal war, how and which methods to use, and how to treat people who are caught up. So we know that there are those fundamental principles that are there, first of all, when you're looking at what is in international humanitarian law. First, the role of the humanitarian workers on just reducing the effect of conflict. So what are the methods in armed conflict? And how do you use and can you use force? Let's look at the origins of this law. One of the first ones that we look is what is known as the Kellogg-Briand Pact of 1928. This was a pact that was entered into between the US, Germany, and France. You will notice that this is after the First World War. The First World War actually taught the countries on how conflict can actually affect the whole world and that there are no winners. You know about the Paris Pact and the steps towards creating a League of Nations. After the First World War, countries just felt the need to come together and try and see if there was any method where they could just mitigate the effects of war. Already there was a realization that war is very harmful and the effects continue for such a long period, and perhaps that there should be a more peaceful way of dealing with disputes. So in the Kellogg-Briand Pact, which was signed mainly between those three countries, the US, France, and Germany, you have Kellogg, who was representing the US, and Briand, who was representing France. They sought to reduce the effects of the harm that was being meted out. They just tried to come up with a way that disputes could be settled amicably. This, although it did not last for very long, it already set the path on how people can be treated. If you go back, then looking back at the First World War and the Second World War, which actually created the preamble to the UN Charter. The First World War was fought by so many countries, and the effects were so devastating. But the Second World War now just changed the dynamics. By this time, countries were more technologically advanced. There was use of machine guns, there was use of bombs, there was use of just chemical warfare. There was serious aircrafts were now in place, so you could bomb a country, just have a lot of aerial bombings. And all this led the countries to realize that there was a need to come together and just look for other peaceful methods. Because of also the bombing that we saw in Hiroshima and Nagasaki, realization that we could actually destroy our world. So the First and the Second World War needed the countries to take a step back and think, yes, there is conflict, but how can we mitigate it? How can we handle it? We know the place of customary law. Customary law is just the law that has been passed down through the ages and practiced. And we've looked again at situations where how war was handled, where there is conflict. How do you treat people who are prisoners of war? How do you treat people who are wounded? All that. Another very important origin of this war is what is known as Caroline's case, which happened in 1837. This Caroline's case, which is also known as Caroline's affair, was a case that was a diplomatic crisis that arose between the US and British North America at that time, currently what we know as Canada. Canada was a colony of the British. It was a colony in North America. And because of that, you know, they had a sovereignty over that area. However, there were some rebels who are fighting against the British government in Canada. And these rebels would sometimes cross over to the US for safety. So at this time, the US actually, on the side of the US, were some people who were supporting these rebels. So in this particular incident, they would actually send them supplies, supplying the rebels so that they are able to continue fighting the British. Now, the British, of course, conducted their investigations, and you know, the British were very good warfare. And in the area which is currently now known as Ontario, they went and found this steamer, which was known as the Caroline, which was moored on the side. This is the vessel that was being used by the rebels. So when they found it there, they chased it, and they found it on the side of the US. You remember, if you know if you go back to your geography and look at the Niagara Falls, half of it is in Canada and the other half is in the US. So this steamer was banked close to the US side. But the British, once they saw the vessel, of course, wanted to destroy it because it was being used against them. So what they did is they set it on fire. They actually set the steamboat, the Caroline, on fire. And then they let it sail all the way out and fall down the Niagara Falls, totally destroying it. Unfortunately for them, one man died of American nationality. So obviously the US wanted to be involved because a national of theirs had died. And this became a big diplomatic crisis of how do we resolve this issue? How can you come into our sovereign waters, take this boat, set it alight, and destroy it completely? But the British argument was that this boat was being used by rebels against us. We are acting in self-defense. So the question came about of, is it self-defense when you come and attack a boat which is on our side? And the British we have every right, because it has rebels who are attacking us, we have a right to destroy it. So that was the background of actually the case of the Caroline. And we'll see why we talk about the story of the Caroline, because out of it came some principles of self-defense, which are in use up to today. They are still referred to when we talk about use of force when it comes to self-defense. One of the most important, again, principles we look at is the general principle in international law of non-intervention. The UN Charter under Article 2 talks about non-intervention. It talks about sovereignty of states, and how, as much as possible, countries should not interfere or just use of force in another sovereign state. Looking at the background of how this came about, and because international law is all about states agreeing to be bound by the instruments, we have quite a number of laws which cover this area. We have the Hague Conventions of 1899, which were then revised in 1907. We then have the first and second Hague Conventions of 1899, and then we have the 4 Geneva Conventions. These Geneva Conventions actually address how force will be used and to which people. Further to the Geneva Conventions, we have also additional protocols. A protocol is an addition to a treaty. We've already talked about Article 2.4 of the United Nations Charter. I'll read it for you so that you can see what the whole genesis behind it is. 1, that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. So the term law of war, and this is the one part where war is used, refers to both the rules governing resort to force, jus ad bellum, and the rules governing the actual conduct of force. So there are 2 things that we are looking at. 1, there are rules which govern you before you get into war. And then there are rules that govern you on when the war or conduct when you are already at war. What are we entitled to in war under the UN Charter? So the United Nations establishes a fundamental distinction between legal and illegal resort to force. So basically what happens is that it goes back to the international law and looking at what is a just war and what is an unjust war. Now, it's difficult because every country will feel that they are justified in getting into war. But these instruments sort of give guidelines on how you can get to this area. During the Paris Pact, there was a move to try and just regulate countries so that before you go into war, that you first have to follow some steps. 3 months before the war actually takes place, you should inform the other countries. It was just a move to try and just amically resolve these disputes. But of course, no country wants to be held accountable by another country. So the countries that failed, the Paris Pact failed. Exceptions to the prohibition on the use of force, which is why we go back to the Caroline's Affair case. You remember in Caroline's Affair, the British were saying that they are entitled to self-defense. Now you see self-defense coming in under Article 51 of the UN Charter. So this self-defense has been recognized. And you see that some of the deliberations that were there during the Caroline Affair were actually included in this. There is the quotation which says, "Nothing shall impair the inherent right of an individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken the measures." Basically what they're saying is that a country is allowed to defend itself. Usually the Security Council will want to play a role if you're a member country and see what measures have been taken by the member states. But basically every country has a right to defend itself. So when you're using the principle of self-defense, like we saw in Caroline's case, and if you look at Caroline's case and decide what points must you take note of so that you know that you are entitled to self-defense. 1, you have the principle of proportionality. What does that mean? It means that the action you take has to be proportional to the attack maybe you're receiving. If we look at the case of the Caroline, there was a big uproar because of the feeling of why would you put a ship ablaze and send it down the Niagara? What were the effects of it? Oftentimes this has to be taken into consideration. Even if you have rebels or another country, the attack that you give, is it proportional to what you are receiving? The principle of proportionality. The other principle which is there is necessity. Is it necessary for you to take over military action? Is there anything else that you can do other than engaging in military action? How necessary is it for you, even though you're protecting yourself, to engage in this military action? A third point, which also came out of Caroline's case, was the one of immediacy. Was it immediate? If perhaps you follow the rebels, like in the Caroline's case, and they dock on the side of the US, it is immediate. Maybe they are coming towards you. How do you defend yourself? The issue of immediacy is also taken into consideration. And then overwhelming. Is what has been done overwhelming? Or is it just so minuscule that it shouldn't actually make such a big difference? What is being done? How do you handle it? In recent years, we can see some cases where we've had conflict. A good one is the issue of Kuwait and Iraq. We saw Iraq invading Kuwait, and we saw what they did there. The army moved into Kuwait, and one of the things they do was start putting their oil wells on fire. We've seen this also in Israel and Iran, where Israel, again, was anticipating an attack from Iran, and they then go ahead and make an attack themselves. So what is the place of anticipatory self-defense? The question is, can you anticipate an attack and do something about it? What if, as a country, we feel that one of our neighbors wants to attack us? Can we attack them first? Will that be anticipatory self-defense? International instruments usually will not support anticipatory self-defense. International instruments will usually not advocate for anticipatory self-defense, because you don't know how it was going to go. Perhaps there would have been some settlement of this dispute. Use of force. How is force used? We've seen that before you use force, the UN under Article 51 will have something to say about it. But they have something which is called collective self-defense. How does this work? Again, to give you an example of Kuwait. Once Iraq invaded Kuwait, you'll notice there was the Kuwaiti army. But other than that, the allies, countries like the UK and the US, collectively went into Kuwait to defend Kuwait. So it was collective self-defense. Collectively, these countries were defending Kuwait against the aggressor, who was Iraq. You can have the Security Council under Chapter 7, Article 42, allows for that. We've had a situation where force can be used to compel a state to comply. In the case of Grenada, Grenada was having some civil disturbances, and there were some American citizens who were held up in Grenada, and the US asked for them to be released and brought out, many of them students or just some people who are working there. And when this did not happen, then the US went into Grenada to bring back their nationals. One of the most and actually interesting things about humanitarian law is the fact that the weapons that we used and the method of warfare are actually regulated. You, just because you're a big country and you have all this, you are not entitled to use any method of war that you may want to. Remember that the only legitimate object of war is to weaken the enemy's military forces. That's the only legitimate method of war. Not to destroy the city, not to take as many prisoners, but really to weaken the enemy's military forces. And you must underline and highlight that. When you get that, then you understand why the methods of war are being prohibited. So that means you cannot choose any method of warfare. It is not unlimited. You cannot employ any method. So this is really important. And we have very many treaties which prohibit this use. One of them, some of the methods that are prohibited are terror and starvation. We know the place of terrorism. We know the place of starvation. Long ago, we'd see that soldiers would come, warriors would come and around the city and circle it so that the people actually are under siege for days and maybe months. Eventually they run out of food, so there's starvation and they have to come out and you conquer the city. This is not a method that is acceptable. So you cannot push people to a corner and then allow them to starve, so that you make sure that they have no food resources, and because of that, they are now, that is a method of warfare which is actually prohibited. Another big one is reprisal against non-military objective and indiscriminate attacks and damage to the natural environment. The first one, when we look at it, non-military objectives. Remember that the whole point of war is to weaken the military. So you should not attack non-military objects. So you attack a military base, you attack a military camp, you attack all that, but not civilian objects. That is not allowed. Secondly, you can't have indiscriminate attacks like we saw in the Second World War, when we'd have the bombing of London. Day after day, you just keep on bombing, irrespective of where you're bombing. That is actually prohibited. You are also prohibited from attacking installations and other dangerous forces. I'm thinking of a situation where maybe you attack like industrial area where we have so many chemical factories. The point of it is to maybe have a fire that just raises out the whole area. That is actually prohibited. Also installations like Kenya Power and the water supplies, that is prohibited. What is also prohibited is ordering that there shall be no survivors. We've seen situations where, especially the US has been a little bit of trouble when they go to some areas and then kill everybody in the village. That is actually against the international humanitarian law, and one can be sanctioned for war crimes. Taking hostages and taking advantage of the presence of civilian population. This we find a lot. Some of the targets that one is not allowed to attack under any circumstances are hospitals, schools, churches. So what happens is sometimes rebels will go and hide. So even the military are not allowed to go and hide in those areas with a view to attacking their enemy. That is also prohibited. Improper use of distinctive emblems. We've seen the use of, say, the Red Cross and the Red Crescent. So perhaps painting your military vehicles with a Red Cross sign or the US peacekeeping sign, but with a view to spying on another country or attacking them. That is actually prohibited. So there are so many methods that are prohibited. For us, especially here in Africa, one of the methods that has affected us a lot is that of mines. We have seen the effect of landmines in Angola. We have seen the effect of landmines in Mozambique. This continue to make the people suffer even after the conflict has ended. Large tracts of land are not usable. You cannot farm because of landmines. We find that many of the victims are actually children who, when playing, step on these landmines. You then have, after the conflict has ended, a whole community of people who have no limbs. And how do they then grow after that? So we have some treaties which ban some of this use of some of these methods. We find that some methods of war which have been banned include using some bullets. There are some bullets which actually explode on impact. Remember, and always remember, that the whole purpose of war is to reduce the strength of your military opponent, not to make him suffer. Things like rubber bullets, plastic bullets have been banned because they are harder to heal. When somebody is shot with a plastic bullet, it causes a lot of suffering and they die. The point is not to make anyone suffer. The point is to just reduce the military. So note all these methods of war which have been prohibited and see the place of these international instruments. And remember that it applies to international conflict and non-international conflict. Thank you very, very much for your attendance.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.